Okay, so let's get much more in depth into the judicial branch and looking at the Supreme Court and their cases and their actual powers and writs. Now, in the landmark case Marbury versus Madison at 1803, I can't emphasize enough how important this case is. The Supreme Court ruled that it had the power to declare congressional and executive actions unconstitutional. The case itself is kind of interesting in the sense that the ruling itself appeared to weaken some of the court's powers up front, but in the end, it led to the power of what's called judicial review. So now the Supreme Court can review lower court cases and congressional legislation like bills and laws or actions, and they can also look at executive actions, executive orders, and what the president has done. Are treaties constitutional? Any of that stuff can be declared unconstitutional because of the Marbury versus Madison case. And this is established in 1803, very shortly after the United States it ratified the Constitution in 1788 and 1787. Under judicial review, the Supreme Court can determine a congressional or presidential action is unconstitutional. We also said there's presidential executive orders, anything. If it goes against the Constitution, of course, it can be challenged. Now, just to be clear, because there's some confusion, things do not go directly to the courts or the Supreme Court. They have to be taken there. So people say, well, yeah, but I mean, people are breaking these laws and blah, blah, blah. This is happening. The president did this. It has to be taken to court in order for the Supreme Court to review it through judicial review. There are some exceptions like elections and issue, like an election maybe, but I don't want to confuse you, where it could go and be reviewed under if there's some technical things, but for all intensive purposes, we want to understand that it has to be challenged by lawyers or groups, or it could even be a party. They have to sue the president or attack a bill and say it's unconstitutional. Until that point, that is law of the land if it's passed by the legislator. And then if the president is doing something and then it's not being challenged, he's probably going to get away with unconstitutionality. Now, the term judicial review is not in the Constitution. It's actually not in there. And we're going to learn where it comes from. But there's nothing in the Constitution under Article 3 about the Supreme Court. Remember, in Article 3, it only really talks about the Supreme Court. It doesn't establish to other courts. Legislative branch has to establish to other courts. And the president chooses, it tells us how the president chooses the Supreme Court. And they're confirmed by the Senate, but it doesn't describe the judicial review idea. Supreme Court was very weak originally in the Constitution. Okay. Now, where is it actually found is in Federalist 78. Judicial review is actually a concept that's really termed by Alexander Hamilton. Alexander Hamilton argues in Federalist 78 that the judicial branch will be the least powerful branch, okay? He argues that the justices will serve for life with good behavior. So we get into this idea of good behavior, serving for life, okay? He also argues that in the Supreme Court, responsibilities declared congressional and presidential actions unconstitutional. He established this idea of judicial review. He says the Supreme Court has a responsibility to uphold the Constitution above all, above the president, above the legislative branch, and he establishes a checks and balances in this document, Federalist 78, but it's not actually in the Constitution, and we can look at that document. So I want you to understand the big ideas in Federalist Paper 78 came true. Judicial review, because of Marbury versus Madison, is in fact the big idea that has happened today. The Supreme Court can declare this stuff unconstitutional. And the second thing is judicial justices will serve for life for good behavior. He won that argument. He did not win with president. Presidents have to be reelected every 4 years. But he had won that argument in 70. In Federalist 70, he argued the president should be for life with good behavior. Once he gets elected, that's not how it works, though. Presidents are limited because of, but not because of the main Constitution, because of the articles that were added afterwards, the amendment to the Constitution after FDR limits the terms. We're called term limits. Okay, So you have to think about if they're looking at this, they're really going through the information, what's the best idea that it describes. This is the power of the court to review decisions and change outcomes of decisions of lower courts. So when they're looking at this stuff and they're reviewing it, and then they're doing what? Is that original jurisdiction? Is that judicial scrutiny? Is that appellate jurisdiction? Or is that federal jurisdiction based on what we know? Think through this. Okay, and that's judicial scrutiny. Judicial scrutiny is scrutinizing, looking through previous cases and changing the outcomes. Okay, so looking at precedent, seeing that there's something unconstitutional or on a lower court, and then they scrutinize it. They override lower courts. Supreme Court is the highest court of the land, the federal Supreme Court. Just like Missouri Supreme Court is the highest law court in Missouri. Now, some other rules that come out that are very important cases that are established under the Supreme Court, and we're much more in depth in the Bill of Rights where this stuff comes from, but it's in the Constitution, in the Bill of Rights, is this idea of the exclusionary rule. Okay, so it's not actually written in the Bill of Rights, but it's interpreted to be there as a civil liberty. If it's in the Bill of Rights, it's a civil liberty. The exclusionary rule is this legal rule based on constitutional law, saying that the evidence collected or analyzed is violated of the defendant's constitutional rights. Sometimes it's inadmissible for a criminal prosecution in a court of law. Okay, so if evidence is obtained unconstitutionally, according to the Supreme Court, it's inadmissible, which means it cannot be used for criminal persecution. So this is a criminal courts again. So, and this is based on a famous case we'll get into. But so, for example, you can see the police are kicking in the door without a warrant. Okay, and we've talked about if they're kicking the door and they're searching your house for drugs without a warrant, and you have not given them permission to enter the premises, that should be covered under exclusionary rule. So if they do find drugs in the house, that should be thrown out and can't be used against you in a court of law. Okay. Now there is one exception, and the big exception is, in fact, we know under the Patriot Act, if you're suspected of terrorism, they can kick into doors, and the Fourth Amendment does not apply under this law. And as of now, the Supreme Court has not overruled and said that's unconstitutional in the case of terrorism. And the argument is the executive branch needs to move quickly in the case of terrorism. They have time to get warrants. But if you think of what a warrant is a warrant is a check and balance in itself. The judges have to give the police or the FBI or whatever law branch of the law permission to enter the premise or permission to go into your car. Okay, and under the exclusionary rule, if they don't have a warrant, that information, that evidence is thrown out. Also, we'll get into the more technical side of this is if they do get a warrant and they are going into your house or somebody's house and they said that the warrant, and this is what poor police work unfortunately can have serious consequences, is they say they're looking for drugs and they're only looking for drugs and then they find a bunch of illegal weapons. You cannot use the fact that you as a police officer found the weapons there. That does not count. It's exclusionary rule. It's not in the warrant. You didn't ask permission to look for illegal weapons. That's why if you're a good police officer and he or she's doing a great job, you have to go to the judge and you have to get clear objectives on what you're searching for under the exclusionary rule. You're searching for guns. You're searching for drugs. You're searching for paraphernalia. Whatever you're searching for. You have to be clear what you're looking for when you have a warrant. And that warrants also are not just limited to the house. It could be for a warrant to go into somebody's computer, warrant to go into your car. We'll find out that you don't need a warrant to search somebody if you have probable cause, but for places, okay? So another idea, this is really established in this case called Mapp versus Ohio in 1961. So again, this is something that's interpreted to be a civil liberty in the Bill of Rights. It doesn't actually say exclusionary rule. This has been established in this famous Supreme Court case. It set a precedent for which is a ruling or a decision that set a strong, valid example for the future. All evidence obtained by searches and seizures in violation of the Constitution is by, and then it should be the Fourth Amendment, inadmissible in a state court. Mapp had been convicted on the basis of illegally obtaining evidence. So what the case is in Mapp versus Ohio is she and her lawyers sued the state of Ohio in 1961. She was actually, they were looking for, I believe they were looking for pornography, and at the time, which was illegal in Ohio, illegal pornography. And what happened is they found gambling. They found a lot of gambling and misinformation, or gambling, and what they did is they charged her with the gambling. And in 1961, she sued Ohio and said, her lawyer said, you can't do that. It's against the Constitution. They were looking for pornography, and then they found my gambling. I was gambling, or I had illegal gambling, and they entered my house on the premise with a different objective. And the Supreme Court ruled that's true. Now, the next case we talk about is Miranda versus Arizona in 1966. Also an extremely important case. This is Miranda versus Arizona. And these are interesting cases, and the details of them can sometimes be really gruesome, unfortunately. But they're extremely important cases. You guys have maybe heard of your Miranda rights. So in Miranda was actually, he was a man that had raped a woman. And I say that clearly because he admitted to it. He raped a woman. There was strong physical and evidence that the man was, in fact, guilty. And he was sentenced. And then his lawyers and him sued the state of Arizona and said, under the Constitution, you have a right under the Fifth Amendment to understand and know your rights. And he said he didn't understand his rights. And the reason I know he did it is because he told us. He literally described how he tortured and raped this woman. However, the Supreme Court ruled that that is correct, that we all have a right. The police officers in law have to, in fact, inform you under your Miranda rights. So that's why they say they read your Miranda rights. And if somebody has not been Mirandaized, which means that they have not received the Miranda rights, anything they say or do at that point cannot be used against them in a court of law, if you've heard that. So you have a right to an attorney. So they're informing you. And that's another important case, that now we actually have public attorneys that are provided for us. That was not always the case. That's only been for really a few years in the United States that we've been provided an attorney for us. But now you have a right to an attorney. If you cannot afford one, one will be provided for you. Okay, we're going to pay for your attorney. Anything you say or do can be held against you in a court of law. Okay, so that's the fifth. They're teaching the Fifth Amendment. You don't have to testify against yourself. Now, what I think most attorneys would tell you is, first of all, contact your attorney. If you're 100% innocent, always contact an attorney. Okay, first thing is, don't say anything. Even if you're innocent, I wouldn't say anything unless you really have, they're just asking you simple questions. I wouldn't say anything. It's not that you're guilty. It's just if you open your mouth or you say something the wrong way, it can completely look guilty. And there's a lot of video and there's a lot of documentation of people that have pleaded guilty to cases because police officers have the right to interrogate you and try to get the answers as long as they're not torturing or abusing you. So there are techniques they can use, like good guy, bad guy, cop, and all this stuff to mentally try to convince you to say things. And one of the most famous cases is Central Park 5, which these 5 boys in New York they basically testified that they had raped a white woman in Central Park, New York, in the 80s. And I remember this even as a kid. And they went to jail. And then later on, they were found completely innocent. They didn't do it. And they had described things that were completely inaccurate because none of them even knew what the girl looked like, the woman looked like, because they didn't do anything wrong. They weren't even in the right part of the park. And the big argument is because they were all Latinx or African-American boys and teenage boys between like 14 and 17 that they're just trying to get out of there. And mentally, the cops were yelling at them and telling them to give them the answer. And it worked. So I would always have an attorney, even if you're innocent. And they could have had attorneys in the 80s to protect them. And those guys went to jail for 17 years until the guy that actually raped the woman admitted it in prison and because he thought it was funny that people went to jail for his crime. All right, and told another inmate. The Supreme Court is the most powerful court in America and has made such important decisions as Roe versus Wade, we've talked about, which made abortion legal in 1973. So Roe versus Wade is precedent. It is a case that was really hard to overturn. However, there's a lot of controversy now because there's more conservative judicials on the Supreme Court now than liberal judicials. So therefore, the question is, would they actually overturn Roe versus Wade? And we'll talk about that's an actual example of in court. You got Brown versus Board, which made segregation of American schools by race illegal in schools, and that's a very important case that we studied. We studied that last year in American history. We talk a lot about Brown versus Board. That what the precedent was Plessy versus Ferguson in 1894, which said that you could have separate trains, because Homer Plessy was on a train, and he was like 1/32nd black, and they told him to go to the back of the back car of the train, and he said, no, that's not right. And instead of doing anything illegal, he sued them, and unfortunately, he lost. And the Supreme Court in 1894 said, no, as long as the train cars are equal, then you could segregate or separate people. And that continued till 1954, 60 years. And they finally said in 1954, the Earl Warren Court said, no, separate is inherently unequal. And that's why we don't have single-sex schools, because, again, then that means that females and males in public school, and this applies to public school, could get inherently unequal education. So here's some Supreme Court justices. Obviously, unfortunately, Ginsburg has passed away. She's been replaced. But you had 3 women, 6 men. The 2 guys at the top are Trump nominees. You got Kavanaugh. And then you have Breyer. This is interesting. Probably the most liberal judge is probably Breyer, the guy on the far left. And this is where it gets interesting. If people, they stereotype or generalize, the African-American man, Clarence Thomas, is probably the most conservative judge by far. Alito's pretty conservative as well, the guy to the right, far right. But those are the really, really, really conservative judges. Not that the other ones aren't conservative as well. And then Kagan is the woman on the top right, and Sotomayor is on the left. She's the first Latinx female Supreme Court justice, and they tend to be much more progressive. Ginsburg was pretty progressive, but Kagan and Sotomayor are very liberal. Breyer, the guy with the red tie on the far left, is very liberal too. So you have to actually read about how they rule in cases before you draw conclusions, not just based on their race or if they're male or female. There are 9 Supreme Court justices. That number has been standing. There has been talk of expanding the Supreme Court, especially liberal Democrats think that they should expand the Supreme Court right now because there's more conservatives than liberal judges. Roberts is the guy in the middle. That's the Chief Justice. And John Roberts, the guy, he sits, and you can always tell a Chief Justice because he almost always sits in the picture right up front in the middle. He makes a little bit more money, and he has a little bit more power than the other ones, but in terms of his actual rulings, he could help drive the court one way, but he only gets 1 vote. It's a 1-9 vote turnout. He's also the guy that would preside over like ceremonial things, like he would be, if there's an impeachment trial, he has to be there for the President Trump's 2 impeachment and possible removal, actual trials in the Senate. He has to preside. He has to sit there. He stayed completely out of it, though. He's let them run the cases the way they want in the Senate, but he has to be there. Justices are appointed for life. We're finding out that, again, Alexander Hamilton got that. He won that argument. The Supreme Court only rules on about 200, 300 cases a year, tops. So chances of you getting your case to the Supreme Court to the Supreme Court is not good at all. Good luck. I mean, you're talking probably 20, 30,000 cases a year in America. The chances you're going to get a case up there are it's not good. And they really don't like to look at criminal cases unless it's something like Matt versus Ohio, because it wasn't his crime, okay? They weren't overturning his crime. They were saying how the information was Miranda versus Arizona or Matt versus Ohio. Her crime was not what they were arguing with the court case. It was the constitutionality of the fact that she was getting charged with something that she hadn't done, or that they had not put on the warrant. So then it was against her civil liberties and the Constitution, the Bill of Rights, okay? Miranda versus Arizona, again, he testified, and told the story. He actually raped the girl. They're not saying that the state courts got it wrong, that the guy wasn't guilty. They're saying that the way that the police obtained the information and that the guy was not aware of the fact that under the Fifth Amendment, you do not have to testify against yourself. That is why he spoke. So his constitutional rights have been violated. Those are the kind of cases that are in the Constitution. Now, so you're looking for a civil liberties or civil rights case if it's a criminal issue or a civil issue, which has to do with suing, as we've talked about, or criminal is state versus somebody to get it to the Supreme Court. And most of the cases are civil. They usually have to do like with lawsuits or things that affect society. And if they're criminal, they tend to be constitutional issues. So like they're not going to really overturn a sentence of a murder. That's not really what they're looking for. Now, if the evidence is unconstitutionally obtained under Miranda rights or something, that's where the Supreme Court might get involved and overturn a state criminal case. But they almost always stay out of it. So what steps does Sandra Day O'Connor have to take to become a U.S. Supreme Court judge, associate judge? So if you're trying to be an associate judge, what would you do? A, be confirmed by the cabinet. B, confirmation by the House of Representatives. C, confirmation by the Senate. Or D, approval by the president and the cabinet. So who approves and confirms? And we've seen 3 judges under President Trump be confirmed. Well, it's interesting to see how many are going to be confirmed under Joe Biden, if any. Okay, and the answer is confirmation by the Senate. Just like his cabinet, the confirm and consent goes to the Senate. The Senate, they give consent and they give advice. So they advise and consent on treaties. They have to ratify it. On cabinet members, they have to vote for them with a simple majority. And then on Supreme Court justice, again, simple majority. So that's why it was really easy for President Trump to get 3 candidates through, because he had a majority of Republicans in the Supreme Court, and they're more than happy to get conservative judges on the court. Just like if Joe Biden gets to replace somebody, they're going to move pretty quick